Hello and good morning, everyone. My name is Jillian Bender-Cormier with Bender Insurance Solutions. We want to welcome you to another educational Bender U webinar, Construction Contract and Employment Law for 2026. Some housekeeping notes. If you have any questions during the webinar, please feel free to type them into the Q&A section. We'd like this to be an interactive experience, so our presenters will be available to answer your questions in real time throughout the webinar. During our additional Q&A time at the end of the presentation, I will be sharing other questions you might have with our speakers. We want to be conscious of time, so if we don't get to answer all of your questions, we will gladly reach out to you individually after the webinar. You are all in listen-only mode and will remain muted throughout today's session. This session is being recorded. At the conclusion of the webinar, the recording link, as well as a copy of the slide deck, will be forwarded to you. We have an incredible group of experts sharing with us this morning, and to introduce them, I'd like to hand it over to our Vice President of Construction Risk, Edward Johnson. Welcome, Edward.
Thanks, Jillian. Good morning, everyone, and welcome. Thanks for joining us today. We've got, as Jillian mentioned, a great lineup, and don't worry, there's no pop quiz at the end, unless Ken brought one. In that case, we may be in a little bit of trouble. Speaking of Ken, let me start with him. Ken Schumacher is a partner at Murphy Austin and has spent his career navigating the twists and turns of construction law. He's worked with just about every player in the industry and has a real talent for breaking down complicated contract and claim issues. He's also a frequent speaker on all things construction law, so we're excited to have him share his expertise with us today. Along with Ken is Scott Alexander, another seasoned partner at Murphy Austin, and he previously served as the managing partner for more than a decade. He's handled major construction and real estate dispute issues across California and some very large and complex cases, no doubt. He's widely recognized for his depth of knowledge in the field, and we're looking forward to hearing his perspective today. Later on, we'll be joined, he's there, but we'll be speaking will be Aaron Silva. Aaron is the co-managing partner at Murphy Austin and leads their labor and employment law team. He has a strong background in employment law and workplace safety and works closely with employers navigating real-world workplace challenges. Aaron is also a regular speaker and trainer, so he brings both expertise and practicality to the conversation. And lastly, before I turn it over, a personal thank you to these fine gentlemen. We were trying to determine before we started the webinar how long this has been going on, this presentation. We're going to say at least a decade, but we'll need to get clarification on that. We appreciate the partnership and the friendship. And with all of that said, I turn it over to these fine folks so we can let their knowledge just wash over us through the web, and we all become smarter. Gentlemen.
All right. Well, good morning, Edward and Jillian. Thank you very much. And to everybody who's joined us, we appreciate it. I think we saw the list of names of folks attending, and it's a lot of folks we've dealt with through the years, so we do appreciate you taking time to join us today. Again, we value the relationship and the partnership with Bender. It's been many years, and we do really enjoy presenting every year on legal updates. And so the structure, what we're going to start out is first, Scott and I are going to present on construction law updates and legal changes. We'll start with statutes. We'll talk about a few cases that came down from the appellate courts. And then the second half of the presentation will be Aaron scaring you with all the employment and labor law changes, which obviously there's always many over the course of a year.
Right, and as Jillian mentioned in the intro, to the extent there are any questions that come up during the course of the materials we're discussing today, please feel free to chime in, put those questions into the chat box, and we will address as many as we possibly can.
All right.
So with that.
All right. Well, we always like to start our presentations. What is special about today?
And more than just a decade of listening to us talk about changes in construction law, what is special about today, Ken?
Well, let's talk. It is National Bagel Day.
Ooh.
So hopefully some of you have had your bagels already. We don't have any here in front of us. I wish we did. I will tell you that the two best bagels are either New York or Montreal bagels. So I don't know what your preference is. My preference is New York, but I digress. It's also National Hat Day. I don't think any of us are, well, maybe some of us are wearing hats. We're not wearing hats, but and I don't know who came up with National Hat Day, but it is January 15th.
And it also is a close runner-up. It's also National Strawberry Ice Cream Day. Didn't quite make the cut to get into the what's special about today, because most people don't like strawberry ice cream. But there you go. So a lot happening today, January 15th.
So hopefully you learned something already about what today is. All right, well, let's start with the new construction laws for 2026. So the first couple of laws we're going to be talking about have to come out of the CSLB and have to do with licensure. Every year, there's usually 2, 3, 4 license law changes. And so we like to start with those. So the first is SB 291, which amends certain aspects or sections of the Business Professions Code. And this has to do with workers' compensation insurance and exemptions from workers' compensation that in terms of what has to be submitted to the license board. And so effective, and actually this is effective January 2027. So you do have a year to implement any of these policies. And basically starting in January 2027, to extend a contractor submits an exemption indicating they do not have employees. So they are exempt from workers' comp insurance, that they have to present that and also have to be subject to an audit validating that they do not have any employees. If there are any fines or violations, now the board will assess them between $10,000 and $30,000. So I don't know if any of you are exempt. I think most of your entities do have employees, do have workers' compensation, but to the extent there's smaller entities that don't have employees, you need to make sure you comply with the exemption and be ready for an audit, and let's not have any violations. The next amendment of also the Business Professions Code has to do with discipline, which the license board once in a while, hopefully never for you, but once in a while does implement. They typically do implement that through the Attorney General. We've handled a few of those types of matters. We tend not to like to handle them. They are not fun, and dealing with the CSLB and the registrar is never easy for the Attorney General. What this changes in SB 779 is actually increases effective July 1st, 2026, the minimum civil penalties for any violations. And the violation is defined as a willful or deliberate disregard of the license laws. And so now they're going to increase the penalties to at least $1,500, or for specific violations, at least $500 up to $1,500. So basically, all this law does is increases the minimum penalties for violations of certain license laws. And again, I assume none of you are going to be dealing with this starting July, but it just shows you that they are continuing to increase the dollar amounts, which goes to the state.
Absolutely, and I think well deserved doing this in some respects, to the extent many of us who, whether you're on Nextdoor, some of those other the neighborhood networking services, you get inundated with handymen and individuals who hold themselves out as contractors yet don't quite have a license. For those unsuspecting homeowners that may engage them, I think we've all seen the comments about the disastrous situation. So this is one, while money goes to the state, I think it's probably a good thing.
Okay. The next license law change is AB 521. So as you know, you have to provide bonds to the license board, a proof of bonding to the license board. And in lieu of a bond, there's also the ability for to do a cash or a deposit of money to the CSLB registrar in lieu of a bond. What this law does is it indicates that if a claim is made on that deposit, that's with the registrar. So if there's a violation and somebody makes a claim, the license board is exempt from liability for legal costs or fees against that deposit. So we'll just say that this is the CSLB protecting themselves and protecting the registrar from any claim that may be asserted against those deposits. I have actually never litigated or dealt with a deposit issue, so I'm not sure what the genesis of this was, but nonetheless, it's new law.
Contact Bender and get the bond if you need it.
Exactly. I think most of you are going to have bonds instead of deposits. All right. And another change, and actually this is not, now we're going to shift out of license law. And this is a change, and I don't know, Aaron, if can actually probably help us with this one too. This is SB 597. This has to do with labor code changes. So, as you know, there were changes to 21.8.7 that then morphed into Labor Code Section 21.8.8, which made payroll obligations and prime contractors, direct contractors, liable for wage claims of subs. So we're not going to go through that whole statutory scheme, which, what do you think, Aaron? Could probably take about half an hour to talk about on its own.
Could.
Okay. So what the change is now that from contracts between January 1st of 2022 and 2026, 218.8 has applied. Now they've added 218.9. And so for contracts after January 1st of 2026, it also again makes direct contractors potentially liable for the indebtedness of labor of subcontractors. And the changes, though, and the exceptions are that it now prohibits a direct contractor from being liable for indebtedness with respect to fringe or other benefit contributions if that contribution payment is made by joint check. So this seems to be, I think, the more substantial, the substantive change now to 218.9. So if you are a direct contractor and you know that you need to make payments for a subcontractor for any of the benefits, perhaps a joint check is the way to go. It also slightly changes or expands the definition of direct contractors under this statutory scheme. So again, Aaron, I'm not really sure if it really has any substantive change in terms of potential liability.
Yeah.
I think it's more just providing a potential exemption for direct contractors.
Right. And Ken, would you suggest for the generals out there any revisions on the contract to address that? Maybe expressly allowing joint checks in those circumstances?
Yeah, and I think most of the prime contracts we work with do allow for joint checks to the extent, but I think we can add definitely a provision that indicates that there's the allowance, and we can also cite to 218.9.
Yeah.
So I know we do have some clients who are watching the webinar. We can talk about that too.
Okay. Transitioning for a minute outside of the labor code, AB 533, which added a section to the health and safety code 32132.6, and this is may not necessarily be applicable to a lot of you that are attending. Some of you perhaps that do work for healthcare districts, but what this statute did is it essentially allows all healthcare districts now to be able to utilize the design build process to deliver projects, as contrasted with the design bid build procedures. And we're raising this because this is kind of an example of when particular statutes, some of which may be very applicable to those in attendance, fall off the books. And what I mean by that is there was a statute a number of years ago, probably about a decade ago, that allowed several specific healthcare districts, and specifically Sonoma Valley and Last Frontier and Mayor's Memorial, may have been one or two others, to use design build. It got tucked away into the code section, and it actually expired, and it was repealed. And there were a number of healthcare districts who wanted to utilize design build to get projects out for bid or to solicit responses, and they weren't able to do so. And it then required a number of the healthcare districts to band together and have this statute essentially renewed, which now allows all districts to use the process. So just an example of owners in particular having to be very careful about what their rights are, how they bid projects.
Yeah, and I think this goes with, we've seen this trend now for many years on different types of projects, allowing design build as the procurement methodology, which I think is something that I think most people are in favor of at this point.
Exactly. And healthcare districts, for instance, are one of a number of different types of public entities that can now also use progressive design build. I think many of you in attendance may have some experience working on progressive design build projects. You're going to see many more public entities, special districts and others that are going to be utilizing that, as well as the traditional design build moving forward too. Okay. Another change to the public contract code, this through SB 409. And under the Local Agency Public Construction Act, there were certain exceptions for various types of public entities that provide essentially, if you qualify under the act as an entity, that allow you to do certain scopes of work to a certain amount without having to competitively bid that work. This particular change allows counties that have a population of 9 million or more individuals to actually avoid competitive bidding and application of some other public contract code provisions if the cost of the work is under $125,000. The law for counties with less than 2 million inhabitants is still, they can avoid competitive bidding if the cost of the work is less than $50,000. And this statute also interestingly makes a specific finding that it's not applicable to the County of Los Angeles because of specific, call it, needs of that county. And there has to be a specific study done in order to evaluate and determine what exceptions may be applicable to the County of Los Angeles. But just know, for those of you who may do projects for county projects, for smaller projects at least, there are opportunities out there for direct negotiations and other procurements other than design bid build for projects now under 125,000. Again,
We do
staying within.
have a question that has come in
Yes.
regarding SB 597. In addition of 218.9, do you have suggestions as how to verify or confirm the amount the joint check payable to the union or liability entity is correct for your particular project?
Okay, so the question is asking, how do you verify? I think
verify or confirm the amount of the joint check payable to the union or liability entity. How do you confirm it's correct for your particular project?
Going back to SB 597, how do you confirm the amount is correct?
When you're making a
Joint check.
a joint check.
joint check, so for like a fringe benefit and
Yeah.
stuff.
Yeah.
Usually there'll be like an invoice. Or
Yeah,
something
so
along those
typically-
lines. I mean, there's
Yeah.
going to be some sort of confirmation that you're going to receive back, presumably. I mean, depends on who you're depositing to, right? But usually there's some sort of confirmation that you would get back.
Yeah, so typically we would have, you see a demand, and I think there would be a verification with that.
Yeah.
And then from that demand, then you know, obviously you're going to confirm, and you're going to confirm also with the subcontractor that they're going to verify that that amount is correct. So I think you can kind of do a check and balance. You're going to have a demand from maybe the union, and then you're going to have a verification and a confirmation from the sub, and then you could even have a joint check agreement that confirms the amount. That's a process we've typically used before too. And then you've got the structure in place to make sure the amount's proper.
Yeah. And Aaron, I would assume if there's a shortage, that especially if it's fringes or other benefits being paid, that you're going to get a follow-up pretty quickly.
Yeah, usually. That's how it works.
So hopefully we answer that question. It's a good question. It's
Yeah.
a matter of just, you need to check and verify on all the different sources.
Thank you very
Exactly.
much.
Thank you.
Okay. All right. Moving on, staying again within the public contract code. This is AB 361. And you probably have heard, those of you who've attended these, Ken and I say, for probably the better part of the last decade, there haven't been a lot of substantial or significant changes on the construction side. I don't know how significant you'd call the next several that we're going to talk about, but I would say more significant than some of the legislative changes that we've dealt with in the last number of years. And AB 361 is one of those. And essentially that's born out of the procurement practices that the UC system implemented over the years, where it used best value procurement as a way to award projects. And because of the reports to the legislature from UC about their view of the successes of those procurements, a number of school districts, and in particular LAUSD, were kind of the beta cases, if you will, for using best value on their procurements. And a number of years ago, statute was enacted that allowed LAUSD for projects in excess of $1 million to have the opportunity, if it wanted to utilize best value as contrasted with traditional design bid build, and potentially design build as well, as a way to award a procurement. And again, taking a step back, when we use the term best value procurement, what that really means is it's a way for the public entity to award a project based on more than just simply the low bid. And it essentially is looking at a combination of both price and qualifications of those who are providing responses to the procurement. What AB 361 does is based on reports that the LAUSD has provided over the last several years, who have also touted the economic benefits and the benefits to the district of using best value procurement. The legislature is now opening up to any school district until January 1st, 2031 to utilize best value procurements for certain projects that are in excess of $1 million. It is still requiring other districts to provide reports to the legislature about the success of those projects. LAUSD doesn't have to any longer, and LAUSD through this legislation is also now allowed to use best value into the future. There's no sunsetting on its use of that process.
And let me add on the best value, it's really comes from the genesis from the federal standard. The federal procurement has used best value for years. I think it's their preferred procurement method, and it's creeped into California year by year. I think this now is going to open the floodgates, especially on these types of projects. So we're seeing just a broadening in California. We already talked about design build contracts are broadening, and now we're talking about best value procurement. So I think California is starting to become a little more aligned with the rest of the country to some extent.
Yeah, absolutely. And those who have experience on design build or progressive design build or some of the other modifications from that procedure, best value is really kind of it may go by other names in those procurements, but that's really the process that's used for selection. And so under AB 361, and I will just touch on this very quickly. So for those of you who may be involved in school district projects where this you will be looking at potential projects that are going to use this procedure. So what this legislation does is it requires the school districts who want to use best value to establish a process to essentially pre-qualify bidders. And it puts together essentially its pre-qualification requirements. It may follow the standard pre-qualification requirements that that are generally utilized in California by the state. However, there is a particular requirement that an entity cannot be pre-qualified or shortlisted unless they provide a commitment to the school board that both that entity and their subs will use the skilled and trained workforce to perform all work, which is generally consistent with design build requirements in California as well. So once the school district then completes the pre-qual, then it moves to the solicitation process, which many of you may be familiar with, but that would be an RFP or an RFQ that goes to bidders asking for the submission of sealed bids. And included in that are a number of things the school district has to do. It has to tell prospective bidders what criteria are they going to use to evaluate those who respond, how they're going to be rated and how it's going to be weighted. So when you answer particular questions or provide information, how important is that in contrast to other questions? And then also, and very, very importantly, the evaluation of bidders has to be done by a process that allows the public entity to evaluate qualifications and cost without knowing who the identity of the bidder is. So that way it's not tainted to the extent that a school district may have a preferred or several preferred contractors, and their ratings or during best value may reflect who that entity is.
Yeah. And so I guess Deb will be in the details in terms of what the ultimate criteria is. We've helped clients put together criteria and scoring, and it'll be interesting to see what school districts focus on in terms of experience. I assume they're going to ask all the same questions about past litigation and claims and liquidated damages and those aspects, but
probably more. And again, based on our experience and what we've worked on, very heavily tilted to, in addition to what Ken mentioned, particular like project experience, but also the assigned staff, project management team, and really having a good understanding, making sure that the assigned team has a good understanding of the project. And I think importantly to many public entity clients, understanding that the team assigned is going to be the team that actually works on that project.
And my understanding, Scott, tell me if I'm wrong, is we're also going to have to list subs.
Correct.
So there's still going to be the requirements under the public contract code 4100 of listing subs over 1/2%. So you're going to have that full listing also. All right. Well, there's another substantive change, as Scott indicated. We saved the juiciest statutory changes for the end. So you've heard a couple of them now, which I think are pretty significant in terms of procurement. On public works projects in California, typically the retention is limited to 5%, and that change came through, I don't remember if it was pre-COVID or post-COVID, but around that time frame. Seems like a few years ago now. So there's been a revision now for private works projects under Civil Code Section 8811, which now tries to harmonize private works projects with public works to limit retention withholds to 5%. So except for some exceptions, and we'll get into that, the 10% for contracts that are issued after January 1st of 2026, retention can no longer be 10%, it can only be 5%. And that includes for prime contracts and also for subcontracts. I did receive 2 reach outs from clients with an interesting question. I don't have the answer because the statute doesn't deal with this. A prime contract was issued in 2025, somewhat design build, and that had 10% retention. Then now subcontracts are being issued in 2026. So are they also going to have 10%, or are they going to be limited to 5%? I think we've sorted them through by basically everybody agreeing now to amend the contracts to have it at 5%. But it was an interesting question just because of the timing of that. But anyway, so the 5% is going to be limited for payments from owners to primes, primes to subs, subs to subs. And the other aspect is that the exception is, though, for primes to subs, if the prime requires a performance and payment bond and the bid requests that, and the sub does not provide that bonding, then there can be an exception where the 5% does not apply and the direct contractor can ask for more than 5%. It can withhold potentially 10%. So that is the, I guess, one exception. Now the other exception, and this is not a well-drafted statute, is that for residential projects, 5% does not apply if the project is not mixed use and does not exceed 4 stories. So we got a double negative there, but basically, if you have a small apartment project that is less than 4 stories and does not have mixed use, then this 5% retention limitation does not apply. So you have to take the 2 negatives, make it a positive.
And that's consistent with what we're going to talk about next,
right?
That limitation. And just as as you're reviewing contracts out there on the private side, I've seen just this month 2 contracts come in from owners who it still just included the typical 10% retention in the contract. So I don't, either it hasn't filtered down entirely, or some owners may just choose to think they can ignore it, but just tuck away that on the private side, it's 5%. And there's no getting around that except in very limited circumstances that Ken talked about.
Yeah, it's interesting because whenever we would help subcontractors negotiate contracts, it was 10% retention. We would always tell the client, we'll try to get 5% and tell the prime contractor, well, that's what they do in public works projects. Well, now we don't have to do that anymore. So it makes the negotiation easier.
Okay, and then I think the last piece of legislation that we're going to discuss this morning, probably the most significant change for this year. I'm sure many in attendance today have heard of this or may have be aware of this in your revisions to contracts for the start of the new year. But this is a change under SB 440, which added a civil code section 8850. And this is known as the Change Order Fair Payment Act. And want to provide a little bit of background. Essentially, the genesis of this is twofold. One, there's I'll call them companion procedures, but similar procedures that have been enacted a number of years ago under Public Contract Code 9204, which essentially provide a framework for the handling of certain claims as defined in that statute on public work projects that requires the public owner to provide certain responses to make payment of claims when they find there's entitlement within time periods, and also to meet and confer and potentially mediate or negotiate with the contractor. So legislature made various findings that it did not appear to be fair or in the best interest of contractors to have a dichotomy, to have that process 9204 applicable on public contracts, but no process applicable on private contracts, where there were complaints that many developers and private owners were slow paying change orders, acknowledged obligations to contractors, yet claimed I can't pay it, don't have money to pay, or simply wouldn't pay, or wouldn't make timely adjustments to contract time when you had delay issues that arose.
Yeah, let me add, I think the situations, and we deal with this all the time, is when owners want to kick the can down the road on time extensions and change orders, right? How many times have we seen that? We'll deal with that at the end. And so you have pending change orders for months or even years, and same with time extensions. This statutory scheme is hopefully going to speed up that process or put a little bit more pressure on folks to actually have to deal with things up front.
Right, exactly. But there are, and you'll see in a moment, there are additional requirements all the way around. It's not only on the owner. There's some requirements on the contractors and subcontractors as well. So SB 440 is applicable only to contracts that are entered into after January 1 of 2026. I've had various questions from clients about change orders on existing contracts that are in effect as of on contracts pre-January 1, 26, change orders now in calendar year 26. This scheme, unless everyone agrees, is not applicable to those, only applicable to contracts that are executed and effective after January 1, 26. And similar to the limitation Ken identified as to the type of projects on SB 61, the exact same definition here, where it is not applicable to residential projects so long as it's not mixed use and is not over 4 stories in height. So it's essentially companion to SB 61. So what does SB 440 require? Well, it really is a 3-step process. And we have the next slide, and I know you all will get a copy of these, provides a chart that may provide a little bit of guidance moving forward. But essentially, the first step in the process is there needs to be a claim as defined under 8850, that is essentially a request for time extension from delay or impacts, or a request for change orders or extra work, or another obligation that the owner is responsible for that's submitted by certified mail or registered mail. Once that is set to the owner, it then sets off the requirements under section 8850, which is the owner must make a reasonable review of the claim. Now, the contractor must also provide adequate supporting documentation for the claim. And actually, the statute says the claimant shall furnish reasonable documentation. It's not defined what that means. I suspect on some projects we may be going round and around about whether reasonable documentation has been provided, but just know that you do need to provide at least some backup and support that reasonably identifies both the entitlement and the amount of what your claim is.
A lawyer's favorite word, reasonable.
Exactly.
Whatever that means.
Exactly. So once that's submitted, the owner has an obligation to perform a reasonable review. If it determines that some or all of the claim there's entitlement to, the owner has an obligation to pay that within 60 days. And if it doesn't, it triggers several things, including a 2% per month interest. If the owner disputes some or all of the claim, then the claimant contractor then has the opportunity to ask for a meet and confer conference. There's no specific time within which, after the owner initially rejects the claim in writing, that a meet and confer conference has to be requested. But once that is requested, the meet and confer conference needs to be scheduled within a 30-day period. And after the meet and confer conference, if the claim is still disputed by the owner has to put in writing the reasons why some portion or all the claim is in dispute. And I do want to go back for a minute as well, because when a claim is initially submitted, if an owner just ignores it, doesn't respond in the 30-day period, then the claim is deemed to be denied. It doesn't mean that there's a finding of any entitlement. It's just deemed denied. But that also provides contractor and subs, and we'll get to this in a little more detail in a minute, an opportunity to suspend or stop work to the extent that an owner ignores claim that's been submitted. So going back to the meet and confer conference, if a claim is not resolved through that process, then there becomes a mandatory mediation process where the owner and the contractor are required to mediate. And if I believe it's a 10-day period in which a mediator has to be appointed by agreement of the parties. If there is no agreement, then the contractor is allowed to select whatever mediator they wish. If the owner refuses to participate in mediation, that also is another avenue that specifically under the statute that allows the contractor to suspend or to stop work, subject to providing notice. And then if you go all the way through the mediation process and you don't get to resolution, then you fall back into whatever the contract provides as far as litigation or arbitration for how you're going to resolve disputes. So this provides a relatively comprehensive overview of how, if a contractor wants to facilitate review and resolution, or at least bubbling up disputes on claims that are asserted, provides a process to do so. Now, so far we've really talked about just a prime or direct contractor submitting. There's also a provision within 8850 that's applicable to subcontractors. And so to the extent that there's a lower tier subcontractor, and by the way, this does not apply to suppliers, but a lower tier subcontractor who has a claim that is submitted to the contractor, and the contractor is then put into the pivot position, if you will, to make a determination to either pass through to the owner under this process the claim or elect not to do so. And if a general contractor elects not to pass a claim through from a sub, it has to provide within 30 days a response and has to take a reasonable review of the claim and provide a response to the subcontractor explaining why it has elected not to do so. Statute doesn't provide grounds for when and why a prime cannot or can elect not to pass a claim through, but it does say that the decisions have to be reasonable. So we think that's probably another area that may be rife for some dispute. Also, it's not entirely clear as to whether or not a subcontractor may be allowed to stop work to the extent that a prime contractor elects not to pass a claim through. So we expect that there's going to be a lot of dispute issues that are going to be generated from the initial attempts in the first couple of years, first year at least, to try to implement dispute process under the statutory scheme.
Yeah, and I think that the stop or suspending work aspect, to me, it's dangerous. We have clients who have called us through the years, well, can I just stop work? I'm hemorrhaging money, and you got to be very conservative in that analysis. Do you want to stop work? Because you could be exposing yourself. There could be lots of ripple effects. So I appreciate that the statute has this in there, because sometimes a contractor is under economic duress and cannot continue to fund a project given change orders or claims or delays. But I think that decision has to be made very carefully and to make sure you understand all the potential ramifications of that.
Absolutely. And the ability to invoke a right to stop work under the statute without penalty is not immediate. There's notices that have to be provided. There's an initial notice, written notice that has to be provided by a contractor or a sub to invoke their right. That's got to be sent within the requirements of the statute. So it has to be by registered or certified mail. It has to provide detail as to why that right is being asserted. And then there's a 30-day period after that notice is sent that elapses. And then after that 30-day period, if payment still has not been made or there's not a resolution, then a 10-day notice to stop work is given. So it really is a 40-day period. And if the basis of the suspension or stop work is lack of payment, that actually is 100 days, because an owner has 60 days to pay under the statute, and then you've got 40 days of notice. So it would not be immediate. So there's some cooling off period, but still, as Ken said, any election to stop work or how that's handled has got to be handled very, very judiciously. As indicated, so we've got a chart here that may be just a bit of an oversimplification, but may be helpful for those in attendance here, just to get a kind of a visual diagrammatic understanding as to how SB 440 is implemented and works. And it's also important to know that it is illegal. It's not allowed for there to be a waiver of the requirements of SB 440. So parties can't agree. Owner and contractor can't say, we're not going to follow SB 440. However, there can be an agreement to augment or supplement SB 440 with respect to dispute provisions, with respect to how claims are handled, and the claim procedure, so long as it doesn't either dilute or delay or undermine or water down the SB 440 requirements.
So I guess the question I'm sure we'll get is, what if you have a contract that doesn't specifically, so after January 1st, reference 8850 of the Civil Code, but it says all laws apply, all applicable laws apply. I think there could be an argument this is going to be read into any of the private works contracts and should be followed, even if your contract doesn't specifically mention this code section.
Absolutely. So our recommendation is taking the proverbial bull by the horns on this and include the reference to SB 440 in contracts. there are some ways that it can be augmented that may provide some, I could say relief, but that may soften the impacts of this. And it also should be known that this is some aspects of SB 440 can be avoided if there is agreement by the parties, not the entire application of SB 440, but the owner and a contractor can agree to ignore the meet and confer requirement after a claim has been submitted. You can agree to modify the time periods after a claim has been submitted. You can agree to defer mediation, or you can agree not to mediate a claim. But all of that can only be agreed to between the contractor and the owner after the claim has been submitted.
And we've seen that a lot. And as Scott indicated, in the public works world, this is similar to Public Contract Code 9204, which was implemented a few years ago. And we've had scenarios where our clients have implemented that process on change orders, and we've reached agreements with owners. Well, maybe we should extend the meet confer for 30 days, or let's make, mediating in 30 days isn't going to work. Let's do that in 60 days. Mm-hmm. So there's ways that you can, after the claims are submitted, to kind of get a maybe a more realistic time schedule for addressing claims, depending on where you're at in your project.
Right. Or bundle claims, or you can agree to have a quarterly meeting. There's different things you can do, especially in larger projects. But I think big picture, positive for contractors, positive for subcontractors, from the standpoint of at least bubbling up to the surface claims. And as Ken said initially, the real impetus here was the desire of many owners and developers to proverbially kick the can down the road. So now they're not able to do so without impunity at this point. So we know there's a lot to unpack on SB 440. If there are specific questions, reach out to Ken and I to discuss, please.
We do have a question that came in, and it was just when you were hopping into this segment, gentlemen. So it was the area right before this. So what the question is, what if it does have mixed use? Is it still 5%?
So it has to be both of those.
Correct.
So mixed use or the 4 stories. So it has to meet both of those requirements.
Yeah.
Thank you. Thank you so much. It came in right when you jumped into this. So perfect.
There's an and there.
Yeah, it's not mixed use and does not exceed 4 stories.
Yeah, I know it's again double negative.
That's what happens when you have legislators draft legislation. They may not have full knowledge, but that's a discussion for a different day. All right, so before we turn to a couple of cases on the construction side, thought it would just be of interest just to raise this as well, especially for those in attendance that do Caltrans work. The DBE program, a lot of changes within the past year. Most know that U.S. Department of Transportation published an interim final rule towards the end of last year, essentially providing that its intent to significantly revise the federal DBE, Disadvantaged Business Enterprise Program. Essentially, that was a piggyback on a case from earlier in 2025, where the DOT proposed a settlement to the court that challenging to settle a lawsuit from a contractor that challenged race gender-based DBE goals on highway projects that receive federal aid. That I believe that submission to the court, I'll have to double check. There were some modifications to it, but I believe that was approved. But big picture is, what does that mean for California? Caltrans has issued a couple different bulletins, but the most recent bulletin that was issued effectively suspended its current DBE program, while certain protections that are kind of linked through the DBE under the Public Contract Code, sublisting, for instance, are still in place. They have suspended most of their DBE enforcement, they being Caltrans, until there is essentially a reevaluation of the program in accordance with the interim final rule. So at this point, there are no longer goal setting, compliance, monitoring, and enforcement. Contract goals aren't set longer. DBE and participation enforcement, the evaluations for commercially useful function reviews, and also the everyone's favorite, the DBE good faith effort evaluations, at least at this point, are no longer being applied. How that changes in the future, we don't know. I suspect, depending on the federal funding hammer, we may be in a landscape where we may not have a DBE application for quite some time, but we'll have to see how that plays out. But we did at least want to highlight that for those who do Caltrans work or other transportation work.
Yeah, we don't know what the ripple is going to be for that on other projects, so non-Caltrans projects. We did have a reach out from a different public entity client asking, who's not Caltrans, asking whether this applied to them, and that's not clear. Correct. But we could be seeing changes. All right, so that wraps up all of the statutory changes for that apply to 2026. So again, as Scott indicated, some pretty significant changes, more than the usual, which is, I don't know if that's good or bad, but nonetheless helpful in some instances. We always like to look at cases that came from the appellate courts. Not a lot this year that dealt with construction law specifically. I don't know why, but that typically we see maybe 3 or 4 cases, but really for 2025, the only case that really came down was this case, Golden State Boring and Pipe Jacking versus Astaldi. And this is a sublisting issue. And basically this was a large Caltrans project where Public Contract Code 6286 applies to the bidding. So it's a different kind of procurement process, but the procurement specifically referenced the protections of subs under Public Contract Code 4107, which is the Subletting, Subcontracting Fair Practices Act. What happened here was a smaller sub, and this was $1 billion project, and I think this sub was $1 million. A smaller sub was not listed because they were less than 0.5%. And they did not reach an agreement on the contract with the prime contractor, who then contracted with a different sub. This sub argued that they should receive the protections of 4107 and should have gone through a substitution hearing. Ultimately, because this sub was not listed and its work did not exceed 0.5%, the courts, and it seemed like a pretty simple decision to me, the courts emphasized that they did not receive those protections. So the prime contractor was able to replace them without going through an entire substitution process. So I think what this case really tried to harmonize was looking at the procurement, looking at other statutes, but when the other statutes reference specifically the protections under Subletting, Subcontracting Fair Practices Act, then those are going to apply. So I think pretty straightforward. Next case is the Lynch case, which is actually, it was from late 2024. So again, as I indicated, not a lot of significant cases in 2025. So we had to reach back a little bit to the end of 2024. And this was a case that had to do with a homeowner suing a design professional, professional negligence, when that homeowner is not in direct contract, or we call it direct contract privity, with the designer. And we've dealt with this on lots of different construction defect cases. And what the courts look at is the Biancongia case, which has 6 different factors that they have to look at to see whether there is what we call a special relationship, where the determination is that the design professional has a duty directly to the homeowner or to the owner, where they can make a direct claim for professional negligence against the design professional. And ultimately, in this case, and we'll go through all the facts, the courts did find that the Biancongia factors were met. And so they could actually sue the design professional. So there are times in litigation where we have to deal with the issue of representing an owner or design professional or contractor. Can you sue the design professional if they are not in contract? And in this case, just again reinforces sometimes yes, sometimes no. It's a factual determination on a case-by-case basis. All right, well, we are almost at 10 o'clock. I think we're a few minutes short of 10, but that covers all of the construction law changes that we know of for 2026. And thank you very much for your time and for listening to us. And we will hand it off to Aaron for the perhaps juicier employment and labor law
Right.
aspects.
And there will be some time at the end, so if there are other questions, particularly on SB 440 or some of the other legislation, just let us know and we'll be around to answer those.
Thank you.
So we'll turn it over to Aaron now.
Yep.
All right, everyone. Another year, 10 years down the line. So we know how we do this. New employment laws for the new year. I will present. It's not in any particular order. Ask me effectively anything that you want to as a derivative of these topics, right? So this just kind of gives us an opportunity to expand on some of these subjects. And then, of course, ask your questions as we go along. The only thing that I ask is that you make your questions broad and general, and so we don't have any potential privilege-like communication. So ask me generally, you know, what would I do, or what would a person do in this situation if an employee does X, Y, and Z, instead of saying, I have an employee that's doing this. So if that happens, I do reserve the right to say that I will take that offline, or we can discuss that later. Okay, with that being said, let's start with the most popular stuff, which is always wage and hour. So the legislature was moderately busy with employees this year. There's one law in particular that I will note that I think it's a very interesting law as to why that obligation is being pushed to you folks, but here we are. But overall, it was moderate, so it wasn't a horrible year, but also wasn't a great year either. So we didn't get something big like the PAGA reform bill that we got last year that reined in some of the PAGA litigation that we were getting. So, and we'll talk about PAGA in a little bit, but we'll start where we always start, which is wage and hour, and specifically the minimum wage. So let's jump in. Minimum wage. So it goes up almost every single year. This year is no different. So we are now at $16.90 an hour. Of course, this doesn't apply to you, but if for some reason you also operate a business that is a fast food restaurant, or you're in the healthcare industry, in addition to being construction, you now have different rules that apply as far as your minimum wage. But for most folks, $16.90. So maybe you have minimum wage employees, maybe you don't have minimum wage employees. But if you don't have minimum wage employees, this also affects you. Since I say the same thing every single year, I'm sure you know why it affects you. And that's because when the minimum wage goes up, the exempt salary threshold goes up as well. So as many of you know, we have exempt and non-exempt employees. Non-exempt employees in California don't get things like overtime, they don't get meal breaks, they don't get rest breaks. But to be an exempt employee, you have to hit certain thresholds. There's several requirements, and there's several different exemptions. But for almost all of the exemptions, one of the requirements is that the employee makes 2 times the state's minimum wage on a monthly basis. So when the hourly rate for minimum wage goes up, that also means that the minimum salary, if you have exempt employees, also goes up. So if you take that $16.90 and you take it out on a monthly basis, your exempt employees need to earn at least $5,858.67. At a year, that is going to be $70,304 a year. So minimum wage can also affect other aspects of what you're doing in the construction industry. There is a tool exemption that exists under the wage orders that says for certain employees, they can be required to provide their own hand tools, or tools that are standard in the trade. The threshold for that is that those employees need to make more than 2 times the state's minimum wage. So that will affect it. And then my contractors that have collective bargaining agreements, there are several exemptions that apply to many of the rules in wage and hour. So overtime, rest breaks, meal breaks, pay stubs, things along those lines. There's a PAGA exemption as well. But usually, one of the requirements is that the employees that are covered by the collective bargaining agreement need to make 130% of the minimum wage. So if you have a collective bargaining agreement, one, you want to make sure that you have those exemptions in place, because they can literally save you hundreds of thousands of dollars. And I've had several contractor clients in the last 2 years who have had collective bargaining agreements, and I have used that to get them either completely out of a lawsuit, or to at least whittle down what the lawsuit is about, taking down the overall liability. So be mindful of that if you are in the collective bargaining world. Minimum wage, we go on from there. Pay scale disclosure. I don't want you to be overly impressed by the graphics that I'm using in this presentation, but if you are, I can't do anything about that. So here we are with pay scale disclosure. So we go back in time a little bit. If you remember the Me Too movement back in the late 2000 teens, one of the calls was to have amendments done to our equal pay laws. So we've had equal pay laws for quite some time now. We have a federal one, but we also have a state one. And not surprisingly, as is typical with employment law, the state legislation on equal pay is a lot more strict than the federal side of things. And for the most part, I usually am, when I'm doing my practice or giving advice, I'm looking at California law. I mean, federal law sometimes comes into play, but usually it's California law that is what I am applying because it tends to be more strict. So our equal pay law is no different. As it exists now, the equal pay law prohibits employers from paying employees less wages for performing substantially similar work based on sex. So it's not just men and women have to get exactly the same. It's men and women have to get exactly the same if they're performing substantially similar work, where a lot of the litigation, if lawsuits are filed about this topic, is about that very topic. So this law, SB 642, did a couple of things. The first part is not surprising. It's very consistent as to where we have seen the legislature deal with gender and sex. But the first thing it did is it amended the law to prohibit pay disparities based on an employee of another sex as compared to an opposite sex, which was the prior language. Like I said, if you know what our legislature has done with the topic of sex and the topic of gender, this isn't anything surprising. The bigger part is what we are now considering wages and compensation, or when you are determining if someone is getting paid less than another person. So under the statute, wages and wage rates are now revised to include all forms of pay, including salary, OT, bonuses, stock options, profit sharing, life insurance, vacation and holiday pay, cleaning and gasoline allowances. Basically, any form of compensation that you are paying your employees, and not just their salary or their hourly rate has to be equal, and that's what's going to go into your equal pay law analysis. So this concept is very similar to what you see with the regular rate. The regular rate is what you have to pay when it comes to things like overtime. So if you're paying someone an hourly rate of $30, but you pay them other things as well, maybe there's a shift differential or things along those lines, or a non-discretionary bonus, those have to go into what the regular rate is. So it is when you're paying overtime, for instance, in that example, that person's getting $30 an hour, it wouldn't necessarily just be time and a half of a 30, it would be time and a half of all of the pay together. So this is just something that's very similar to that concept, but it's something that you need to be mindful of when you're providing your compensation to your employees. Moving on. Pay data reporting. When I do these presentations, and I will do this presentation in some form or another, probably 10 to 15 times. This is the first time I've done it this week, but I'll do it 2 more times next week. I kind of always tailor it to what the audience is. So you're going to get the presentation that's a little different than the ag audience that I'm going to have next week when I go up to Sutter County. But I try to do things that I think are going to apply to most of you folks, or a lot of you folks. So for those of you that have more than 100 employees, you have to submit annual pay data reports to the California Civil Rights Department, formerly the Department of Fair Employment and Housing, and it's for a snapshot period. So what our new law here, SB 464, does is it requires to store that demographic data separately from personnel records. So this is no different than other things that need to be segregated from personnel records. The number one thing that comes to mind would be medical records. So you now have to store it separately. It can't be all together. There are penalties that apply upon the state's request. The other thing that this bill does, that in 2027, there will now be 23 job categories where you're going to be providing information as compared to the current 10 job categories. So be mindful of that when you are submitting your pay data reporting to the state of California as that comes up. All right, so I intermix my updates with what's happening with the new laws, and then also new cases that came out in the last year that I think that are important for employers to know about. This is one of them. So this is about meal breaks. So for employees that work more than 5 hours in a day, they are entitled to get a meal break. Now, if that employee also works less than 6 hours in a day, they have the potential ability to waive that meal period with mutual consent between the employee and the employer. So if the employee works more than 6 hours, sorry, you're out of luck, they have to take that meal break. But for those employees that do work between 5 and 6 hours, under certain circumstances, you can waive that with mutual consent from the employee. Now, that comes from the wage order, which if you don't know what a wage order is, it's effectively the regulations for employees on wage and hour. So we have the labor code. Those are our laws that our state legislature and our governor will pass and then sign to become law. And then we have all these administrative agencies that create regulations for wage and hour. They're called wage orders. So when I use that term, that's what I am referring to. So according to the wage order, it doesn't necessarily say that this needs to be in writing, but if you are an employer and you're having an employee waive anything related to meal breaks, you definitely want it in writing. So I will give you an example. I am currently in a dispute right now where I had an employee that worked more than 5 but less than 6, and she would constantly want to waive that meal break because she had childcare problems. So none of that was documented in writing aside from the time records, which shows that she worked more than 5 hours and she didn't get a meal break. So I have the opposing counsel saying, nope, absolutely, she didn't waive it. And I'm saying, yes, she absolutely did waive it. She talked to her supervisor about it. So at the end of the day, it almost becomes a he said, she said type situation. That doesn't necessarily mean that if I were to go to trial that I would lose or that I would win. It just means that it makes my job a lot more difficult because I don't have something in writing saying what the agreement was. So what this case was dealing with, what is a prospective meal period waiver. So effectively in advance, the employer presented to the employee a document that said, hey, when I work more than 5 hours, but less than 6 hours, I am going to waive those meal periods. The waiver also said that it was voluntary and that at any time the employee could revoke that waiver. So one of the issues that has been around for several years is when an employee waives a meal period, do they have to do it each and every time that they do it? Or can they do what this employer did and have a prospective waiver that says, anytime I'm in this situation, I'm going to waive my meal period? So this case actually dealt with that. And this was a good case for employers because they said, yes, prospective meal period waivers under these circumstances are allowed. Now, what was very important to the court was that it was voluntary. So it said it was voluntary and that it was revocable at any time. So if you are going to do this, it absolutely needs to be in writing. It needs to say that it's voluntary, and then it also needs to say that it's revocable. So I'll give you an example of how there's some nuance to this sort of stuff. I had a meal break waiver come my way last week that a client wanted me to review, and it said this stuff. It said it was voluntary, and it said it was revocable. But at the end of the document, it said, if you're going to revoke this, then you have to report that to. They gave the name of the HR manager and the contact information for that specific HR manager. And my point was, well, what happens if that HR manager leaves? So one, you're either going to have to redo all of your prospective meal period waivers, or if you don't do them, well, now they don't have the ability to revoke it anymore, right? Because that person isn't there anymore. So we had to step back a little bit and say, okay, well, why don't we just make this the position? So you have to contact the HR manager. So I get the position and the contact information for that position as compared to a person. So you need to be a little mindful because on the other side, my plaintiff's attorneys can be very clever. I'd like to think I'm clever as well, but I try to anticipate what some of those arguments are, and that would be one of them. Because at the end of the day, the court also said that there can be other reasons why one of these waivers may not be enforceable. For instance, it's coercive or it's unconscionable. That's a legal term, which basically means that for some reason, either procedurally or substantively, the agreement is unfair. So that is prospective meal break waivers, which if you're doing that, I would highly recommend. And if you don't do that, if you ever have a waiver, get it in writing some way or the other. Either it's an acknowledgement from the employer where it's the actual request, or you have something like a confirming email or something that goes to the employee saying, hey, you waived your meal period, right? And if you disagree, let me know. All right. So this next case, I'm using it to demonstrate 2 points. So if you fail to pay the minimum wage, the employee is entitled to recover the minimum wage, but also liquidated damages. So you're construction folks, so I assume most of you know what LDs are, but basically that's the same amount that's owed for the minimum wage violation. And then again, right? So there is a defense for liquidated damages if there was a good faith in the mistake. Now, again, this doesn't necessarily just apply to employees that are being paid the minimum wage. Here's how it more commonly works, in your industry at least. It's, oh, there's claims that this employee worked off the clock. Or so they started early and they didn't clock in, or they clocked out and they continued working after that. So what that means is for that off that clock time, they weren't getting paid anything. And under state law, someone needs to get paid the minimum wage if they're working. So if they weren't getting paid anything, they weren't getting paid the minimum wage, hence the minimum wage violation. That's how it arises a lot in your industry. But in the facts of this particular case, which went up to the California Supreme Court, we had effectively a property manager. So basically, I think it was an apartment complex, but they had a tenant that provided maintenance work. So instead of paying the individual any sort of compensation for doing that, they allowed that tenant to live rent-free. So later on, things go awry, which is how these matters usually come into my attention, and there was litigation that happened. The trial court, or the employer, because it was an employer at the end of the day, said that there shouldn't be liquidated damages because in good faith they thought that they were complying with the law, including the minimum wage law. And the California Supreme Court comes and disagrees with them. So I want to make 2 points with this case. First one, that first bullet point talking about instead of paying you, we're going to allow you to live rent free, which is really cute. But the problem is in employment law, if you do something cute with compensation, or something really odd with compensation, more than likely it's not going to be in compliance with California law. And this really came to bite this employer, who ultimately ended up being an employer, because this is what they did, right? Hey, instead of paying you, we'll just allow you to live rent free. Now, here's the thing. At the end of the day, living rent free might have been a better deal for this individual than actually receiving a compensation. But that's not what matters. It's not how if the individual is coming out better under the agreement, it's whether or not the agreement and the compensation scheme are complying with California law. So don't get too cute with your compensation type stuff, because it usually leads to trouble in some way. But second point is about this good faith defense for liquidated damages. So this employer just said, hey, I didn't know that I was violating the law. And in California, there's, it's called a tenet of legal thought and theory, which is basically that ignorance of the law is no defense. So if you don't know that you're not complying with the law, that's not a defense. And so this kind of springs out of that concept. But the California Supreme Court said that if you're going to try this good faith defense for a minimum wage claim, you have to show that you actually made a reasonable attempt to determine what the requirements of the law were. And you can't just rely on your own ignorance. So in this case, this property manager did absolutely nothing to see if that this basically, I'll give you rent instead of giving you pay, was legal or not. So they didn't do anything, and they couldn't present any evidence showing what they had done to see if that was actually viable or not. So because of that, liquidated damages did apply. So be mindful. Doing things like this presentation is very good to give you, some updates as to what's going on in the legal field. If you might recall, based on the PAGA reforms that we got last year, one way to reduce the amount of default PAGA penalties that are available if you get sued in a PAGA lawsuit is to take reasonable steps to prevent PAGA violations. And one of those things is to effectively train your supervisors on labor code compliance. So doing those sorts of things can help when you're trying to establish if you made a reasonable attempt to determine what the requirements of the law were in a good faith defense type situation where minimum wages are being involved. Posting. Okay, so remember the law that I said I really don't know why this is being passed on to you and to me and to the three of us, because we're all business owners as well. So this is something that we have to comply with, and it's something that I had to work with my HR manager on rolling out. But let me present it first, and then we can talk about what it is. But it's about a notice. So we have SB 294, and this is a law that gets passed in reaction to what is happening at the federal level with immigration. So we saw from 2017 to 2021 where there was a effective legislative battle that was going on between California and the federal government based on what the Trump administration was doing. And then that didn't exist for 4 years, and now President Trump is back. So once again, we are starting to have these legislative battles where states are doing things to react to what is happening at the federal level. This is one of them. So SB 294 requires employers to provide a standalone written notice to workers. So this is not something that you're putting in a handbook to your current workers and to your new employees when they're hired, and annually to all current employees. So this is not a notice that you do one time. This is a notice that you're going to give when employees are hired, and it's a notice that you're going to do before February 1st of this year, so within the next few weeks. And then you have to do this every year thereafter. But it is a new notice. It is a notice that the Labor Commissioner is developing a model for, and in fact, that model was posted on their website either last week or the week before that, because I've used it a few times. And it's also the notice that I am using here at Murphy Austin. But we'll get into what the notice has to say. But basically, it's about a bunch of rights that employees have. But the notice has to be, or can be delivered in however you customarily communicate with your employees. So that could be, you know, if you actually hand them a paper copy or something, email, text message, provided that the delivery can be anticipated within 1 business day of it being dispatched. So email is usually fine. Importantly, employers need to retain records for 3 years documenting compliance with this requirement. So because you do this every year, that's going to be something that rolls in. So this is yet another thing. Like for instance, say you're doing it by email. This is another email where you're going to have to tuck it into your employees' personnel files, which of course can be somewhat burdensome if you have a lot of employees. But it's a 3-year documentation requirement, and it adds to a lot of other documentation requirements that we have here in the state of California. So what does it have to say? So this notice, which is called the Workplace Know Your Rights Notice, touches on several different things. The first thing, it's a description of basically the workers' comp rights and contact information for the Division of Workers' Compensation. An explanation of an employee's right to receive notices of inspections by immigration agencies and an outline of protections against unfair immigration-related practices, and for those exercising those rights. A statement addressing the employee's right to effectively unionize. Now here's the kicker, a summary of constitutional rights when interacting with law enforcement at work, including the rights to be free from unreasonable search and seizures, due process and protection against self-incrimination, and then finally, any legal developments that the Labor Commissioner deems important for that particular year. Remember, this is an annual notice, so that last bullet point is going to change because what the Labor Commissioner considers to be important that particular year is going to presumably change every single year. So with the draft notice that they did this year, there's a good section in there about Cal OSHA. So that's what they chose to use that notice for on their end. So you can either use the Labor Commissioner's model notice, or you can develop your own. I know of no situation where I would ever advise anyone to use their own notice. You should be using the Labor Commissioner's notice. Otherwise, you're at least going to have to research what does the Labor Commissioner think is important that year and figure that out. So you'd have to go to the draft notice anyways. The other thing is some of these things that are on here, like a summary of constitutional rights, effectively when interacting with law enforcement. So when I was in law school, that is a 3-year program. I took an entire year or an entire semester on criminal procedure. And I did pretty good in that class. I think I got a solid B+, right? But I don't know if it's been 20 years since I took that course and I don't practice criminal law. I don't know if I could concisely come up with what an employee's rights are when it comes to, unreasonable searches and seizures and due process. So that's another reason why you're going to want to use the Labor Commissioner's model notice. Same thing with unionizing. So in law school, I took a semester course on this. I also worked for a while for the public side of things for public unions, or I should say the body that enforces public union rights in California. That's called PERB. So maybe collectively I did 18 months of that stuff. again, I don't know if I could concisely write something in language that would be understandable to employees about what those rights are. So I highly encourage you to use that model notice. It is available right now on the Labor Commissioner's website. And if you remember, it's due by February 1st. So it's in both English and Spanish. I think they have a few other languages available at this point as well because they're rolling it out. But if you have not done this, this is like on your to-do list to do either today or very quickly because you have to get this thing out by February 1st. So there's also a second part to this law, and this is immigration contact notification. So most of you will probably have something in your payroll practices which allows an employee to have an emergency contact if something goes wrong at work. So this is building off of that. This says that you have to allow your employees to designate an emergency contact if you are notified that the employee is arrested or detained at work or during work hours, and you actually have knowledge of the event. Now, this has to occur before March 30th, 2026. Why are we getting this? This is, again, an immigration-related thing. It's trying to address the scenario where ICE comes in and detains someone at work. So now they're putting an obligation on you, the employer, to not only notify people of what their constitutional rights are or some of their statutory rights, which would be unionization, but they're also effectively making it your obligation to, undertake the role of notifying a designated person if someone is arrested or they're during work or at work itself. So you have to give notice. Now, importantly, this law isn't just about immigration. So that it just doesn't apply if it's just ICE, right? If in any circumstance they're detained at work or during work hours, whatever it might be, if someone designates an emergency contact in these situations, you have to reach out. Now, this does not require that the employee actually designate someone. What it's requiring you to do is to make that an opportunity to an individual. So here at Murphy Austin, when we rolled this thing out, I did it a couple weeks ago when we did the new handbook for the new year. I included it, or I should say, I had my HR manager included in the email that she sent out to everyone saying, hey, if you want to have a designated person for these specific circumstances, please provide it to me. Right. So that's something that, I did it at the beginning of the year, but the obligation is to do it by March 30th, 2026. So I've seen a couple of clients where they combine just the general emergency contact with the designated person contact, in one sheet. You can do that. There's several ways to deal with this obligation, but it's an obligation that you're going to have to deal with. So the most important one is February 1st. That's the notices. March 30th is about getting your designated contact back if you're actually going to have employees that choose that option. All right. Okay, so PAGA updates. This actually does not have any cases or laws. I just wanted to, just present what the differences are between these two things. So, like I said, I do this presentation a lot. So I think this is about the fourth time I've done it since mid-December, and then I have it 2 more times. But every time I always review it right before I actually do the presentation. So I was checking it out while I was sitting at the back of the table there. I was looking at this and I noticed that the class action in the PAGA headings, the PAGA heading is not in the right spot. And so that kind of struck me hard because in my mind, I've now presented this chart 3 times in different contexts. And I didn't have that heading right. So I didn't know if, no one pointed that out to me, but, I didn't know if like someone went home upset because I didn't have it in the right spot, but I know that I'm a little upset about it. So I apologize for the error there, but it should be at the very top on the right-hand side. But here's what I want to do. I just want to talk about what is the difference between a class action, what is the difference between PAGA. So PAGA stands for Private Attorney General. So back in 2003, there's all these penalties that apply or that are in the labor code, and usually only the state can get them. Back in 2003, when Governor Davis had been recalled, but before he left office, he signed this law into place. And basically, PAGA says that employees, under certain circumstances, we're going to deputize you as attorney generals. We're going to turn you into the state. We're going to make you private attorney generals and allow you to go get these penalties instead of the state. But if you get some of the penalties, you need to share them with most of them going to the state, but also a portion of them going to the employees that are affected as well. So that has changed as far as the allocation that goes to the state and what goes to the employees. It used to be 75% would go to the state and 25% would go to employees. Now it's a 65-35 split. But anyways, that's what PAGA does. Now, to understand what the difference between a class action and a PAGA lawsuit is, I'm just going to give you a scenario. Assume that you have your employees are all entitled to $20 of overtime pay that you didn't pay them. Okay, so we've got a group of employees all entitled to $20. If the employees want to get the $20 that they're entitled to, their actual pay, they would file a class action to get that. That's how you go about getting wages that are actually due to you. And that chart there just kind of gives you an example of some of the requirements that apply. But because the $20 weren't paid, there's also a penalty for not paying that. So you got the $20 plus you have a PAGA penalty. And the PAGA penalty default is $100 per employee per pay period. Now, if you want to get that $100 per employee per pay period penalty, you got to bring a PAGA lawsuit. So what ends up happening a lot is that a class action is filed together with a PAGA suit, so you have them together. But sometimes maybe there's a statute of limitations that are blown or something along those times. You might just have a class action for the $20, or you might just have the PAGA penalty, so they're not seeking the $20, but they're seeking the penalty for not paying the $20. So that's the difference between the two of them. But oftentimes they are brought together. So the statute of limitations for PAGA is a year. So you're looking a year back from when an administrative notice is filed. With a class action, it can go back 4 years. So the real lucrative money in these sorts of cases for plaintiff's attorney is on the class action side of things, just because you have a longer statute of limitations. So like I said, I don't have any new laws about this, and there are several cases about PAGA that occurred, but I'm just going to summarize them because they're all about arbitration agreements. And this is going to be my pitch to you to get an arbitration agreement in place for your employees. Arbitration agreements, if you do not know, arbitration is effectively private court. So you, instead of going into a court with a judge and a jury, you choose an arbitrator to resolve your dispute for you. And then that can potentially be enforced by court if that needs to happen. So usually plaintiffs in my world, employment world, do not like arbitration because ultimately an arbitrator is going to be making the decision about the legal merits of the lawsuit. Arbitrators tend to be retired judges or lawyers that have been involved in the legal field for many years, and they end up going into the neutral realm. So plaintiff's attorneys on my end don't like arbitration because they prefer a jury. Because at least when I've talked to my colleagues on the plaintiff side of things, they think that juries are more able to be influenced by emotions and things like that, or have outrage and things along those lines. More emotions are involved because they're just not legally as sophisticated as an arbitrator would be, who is a judge or who is an attorney that has gone into the neutral realm. So they don't really like arbitration. But I like arbitration because of those reasons. I now have an arbitrator, so someone that's very skilled in the law, that's going to be making decisions about some potentially very significant monetary things like wage and hour. But arbitration can, cover wrongful termination, right? Emotions are certainly involved there. It can involve retaliation or harassment or things along those lines, very emotional type things. So I like arbitration for that reason. So how do you do arbitration? You have an arbitration agreement. So arbitration agreements, my model arbitration agreement, I think is 2 pages. But basically, it's something that you present to your employees, they sign it, and then if there's ever a dispute, you go to arbitration. Now, very good arbitration agreements, and now I'm going to bring it back to PAGA. Very good arbitration agreements are going to have a couple of different things as it relates to this subject matter here. The first thing is it's going to have a class action waiver. So it's going to say, yes, I employee am agreeing to go to arbitration, but I am agreeing to do that as an individual. I cannot bring a class action or a collective lawsuit. So the effect of that means that if you have an employee that signs an arbitration agreement with a class action waiver in it, if the employee ultimately brings a class action lawsuit, you have the ability to have the class action aspect of the case dismissed. So in the example that I gave, what was it? 10 employees didn't get $20. If one of those employees files a lawsuit, they can file a lawsuit to get their $20. They cannot file the lawsuit to get the $20 owed to the other 9 folks. Now, those are very low dollar amounts. But I've been in the situation with contractors in the last year where I think I have thrown out, or I've had thrown out, 4 class action components to a lawsuit. So you can imagine there's a 4-year statute of limitations. Potentially, this is hundreds or even millions of dollars that you could knock out at the very beginning of a lawsuit if all you do is you do an arbitration agreement right now. So at this point, it is recommended to all clients that you get this in place. So you can get arbitration agreements from lots of different places. Of course, Murphy Austin is happy to do that for you. We do have our model notice that we update when we have primarily judicial or court case updates to arbitration agreements. But there's lots of places you can get these things. But if you get one, class action waiver is incredibly important. The second thing that a good class or a good arbitration agreement is going to have is I'm going to call it a PAGA waiver, but it's not entirely a PAGA waiver. Basically, what it says is that if I file a lawsuit that's under PAGA, I'm only going to be able to initially in arbitration get my individual PAGA penalties. So any of the collective stuff. So for the other 9 folks, maybe at some point I'll be able to do it in the future, but I got to first prove my individual claims have some viability there. So it's not as strong as a class action, but it takes a lot of wind out of the sails of my plaintiffs' colleagues or plaintiffs' attorneys' colleagues when they start bringing these lawsuits. So this was my pitch to get arbitration agreements in place. And if you have some very old ones, like say 10 years old, something like that, maybe even 5 years old, you may want to have someone check it out to see if it needs to be updated, because this is incredibly important. This is, in my opinion, employment law. This is the easiest and most important thing you can do right now to help you with liability. Leaves of absence. So this is an expansion on something that the legislature has had its mind on for the last few years. So every now and then the legislature on the employment side of things gets caught up with some sort of subject. And then we will have several years where they start passing laws on that same subject. So we had it with Me Too, we had it with immigration rights a few years ago, but they now seem to be on a kick about effectively victims' rights when it comes to leave. So this is we had a big victims leave reconfiguration that happened last year that I presented on last year, and this builds off of it a little bit, but it's also a good opportunity to talk about paid sick leave. So in California, you have paid sick leave. The default is employees are entitled to 40 hours or 5 days of paid sick leave, effectively what is ever bigger between those two numbers, for certain specified reasons. So that includes, of course, actually being sick, right? But there's also other non-medical reasons that employees can take paid sick leave. And AB 406 amends that law to now say one of the reasons that you can take paid sick leave is when an employee, including one who is the victim of a crime, is appearing in court as a witness to comply with a subpoena or other court order, or the employee is serving basically on a jury, right? So it's an expansion. It is one of those things that typically requires a handbook revision or your sick leave policy being amended. So Murphy Austin does our model handbook every single year. The way that I do it is I always build off of what happened the year before. So this is one of them. So my model paid sick leave language is now amended. So I actually have expanded reasons why paid sick leave can be taken to include what we have right here. FEHA updates. All right, so FEHA, if you don't know, stands for Fair Employment and Housing Act. It's California's main equal employment opportunity law. So Title VII is on the federal side of things. FEHA is on the state side of things. And like most things in California employment law, FEHA is more protective and more expansive and more strict than Title VII as it pertains to employers. So under FEHA, you have to provide certain types of training. One of them is, of course, harassment training. But what happened in the last few years is that employees were voluntarily starting to train on bias mitigation. So now in some industries that's required, like for lawyers, we have to do continuing legal education. So one of the things we now have to be trained on is bias mitigation. So I did that training a couple days ago. So I did it this week. But a lot of employers, even though it wasn't necessarily required for all employees, are now voluntarily doing that. But here's the problem. A lot of those conversations about bias mitigation training resulted in employees coming to the conclusion that they had biases. So that ran into conflict with another FEHA obligation, which is you as an employer have an obligation to prevent harassment, discrimination, or retaliation in the workplace. So what was an employer to do when they were providing bias mitigation training and they were having employees tell them, I have some sort of bias, right? Under that, prevention obligation, were they letting that person go? Were they segregating their duties? It caused a lot of problems. So from the legislators' perspective, they want you employers to do bias mitigation training, but they came to the conclusion that there was this conflict that existed, and so if that conflict existed, what employers would do is they just wouldn't provide the training if they didn't want to, because they didn't want to come up with effectively this scenario of what do I do when someone tells me that they have a bias. So first and foremost, let's start out with a definition, because SB 303 addresses that situation. So bias mitigation training, what does it mean? So we have a definition. It's training provided for the purpose of educating employees on understanding, recognizing, or acknowledging the influence of conscious or unconscious thought processes and their associated impacts. So that's what bias mitigation training says. What this law is it states that an employee's assessment, testing, admission, or acknowledgement of their own personal bias that was made in good faith, solicited, or required as part of a bias mitigation training does not in and of itself constitute unlawful discrimination under FEHA, right? So it takes some of the pressure off of your back if you're deciding that you're going to do this. I will leave that up to you if you want to do that. It's not currently required, but if you do, this is something that at least gives you a little bit of protection if an employee comes to you and says that they do have a bias. Now, if that happens outside of the context of training, you're probably going to still have that same conflict. But this is specifically about if you're doing bias mitigation training, gives you a little bit of a defense. Let's talk about a case. So this is a harassment case about conduct that occurs outside of work, and also how an employer responds to an allegation of harassment. So back in 2015, we got pretty extensive regulations from what is now the Civil Rights Department saying, what are your obligations to do as far as an investigation policy if you get a harassment complaint? So the regulations were pretty extensive, and it would say, for the most part, I'm generalizing here, that if you get a harassment complaint or one of your supervisors gets a harassment complaint, it has to go to a centralized person. And that centralized person needs to oversee a prompt, fair investigation of the allegations, and then take appropriate remedial action if some sort of misconduct is found. There's lots of other things that are in those regulations. That was one of the first things that really kicked off at least recommendations that you revise your handbook every single year. I mean, that's pretty extensive. So I will just mention now that I am still under the impression that if you have a handbook, it's something that needs to be revised or at least reviewed every single year. If for another reason, I gave you an example with the paid sick leave law, that's going to affect likely your handbook. If that's where you have your paid sick leave policy, you're going to want to amend that, right? So almost every single year, we get at least one thing, but I think this year, off the top of my head, I had 4 that I counted where it required some sort of handbook amendment. But anyways, let's go back to this case. So we have a male employee here that filed an action against a former employer and a former female coworker. This male employee claimed sexual harassment, and he claimed that this female employee had made sexual advances to him at his home and via his personal cell phone, but it had nothing to do specifically with work. So they weren't on the premises at the time that it happened, and it was off hours. So he reports that harassment to his employer, and they decide that they're not going to do anything. They don't have any sort of investigation requirements under those regulations that I talked about, because all of this stuff occurred basically away from work and not during working hours. Here's the important part. And for whatever reason, this company HR representative made mocking and sarcastic remarks about that situation on social media. And so the male employee, at the time, the male employee still worked there, but he resigned, right? And then brought this lawsuit. So I guess the first takeaway is that if you have your HR manager or manager, representative, director, whatever you want to call them, but if they are making comments about HR matters on social media, that's probably a good opportunity to have a conversation with them about not doing that and probably letting them go, because that's not a good idea. And I would say, at least in my experience, that's pretty outrageous. But regardless, that's the facts of this case. So the court had two holdings on that. First, the female coworker's off-duty conduct by itself wasn't the employer's responsibility. So they weren't necessarily liable for that. Probably would have been a different result if this was a supervisor doing it. But regardless, in and of itself, two rank and file, same level employees, one's harassing the other and it's happening off hours, the employer doesn't necessarily have an or doesn't have a liability because of that. But this employer was found liable nonetheless. And why was that? It was because of the employer's reaction to getting the complaint. So the inaction, so not doing anything about it, they should have done something about it, right? Talk to the female employee. And the mocking response, that created the hostile work environment. So it was the response from the employer's perspective to getting the harassment complaint. That created the hostile work environment, and that created liability. So the point of this is that it's very important to have those policies in place about how do you react to a harassment complaint to make sure that you're not getting in trouble for this sort of thing. So, even though at the end of the day, the employer wasn't liable for what was happening off hours, they should have talked to the female employee likely. Obviously it depends on the specific facts that we have here, but just generally speaking, they probably should have done something, right? Maybe this complaint required or necessitated those two employees being separated somehow, like something should have happened, right? But certainly what should not have happened was that the complaint was mocked publicly like this employer, or at least this employer's HR person decided to do. Labor code updates. Okay, so this is one of those cases where it's like, I guess theoretically, I always wondered what would happen if an employer had a lie detector at their accessible, but I've never actually seen it happen. So this is a very unique fact pattern. Well, let's talk about it. So I picked this one because the fact pattern is just really interesting here. So we have a cannabis operation, and we have a plaintiff. During the plaintiff's employment with the cannabis operator, money starts missing. And so one day the employee shows up to work and they are instructed to sit next to a polygraph machine that the employer has. He's hooked up to the machine and he's asked questions about the theft, and he's told, hey, you failed the polygraph, we're going to fire you. And he files a claim for wrongful termination, and there's liability for the employer. So this goes up to the appellate court, and the appellate court says that it's illegal under the labor code for an employer to demand or require an employee or an applicant to submit or take a polygraph test. Now that doesn't necessarily apply if you're going to be employed by the federal or state government, but I don't think any of you folks on this presentation fall into that category. So while the plaintiff was not told that he was actually that he had to take the polygraph, the fact that he was fired because he didn't perform as they thought he should have made it a condition of employment, and so there was liability. So for you employers that have polygraph machines at your ready, do not use them with your employees. So I don't know where you get one. They got one, but if you do have one, don't use it with your employees. And if you do use it, certainly don't fire them, because it's going to create liability for you. So interesting case. There's always, every couple of years, you always get one that's a little bit odd. And then we are approaching the end of my portion of the presentation. So if you do have questions about anything that I presented, you can go ahead and get that in. But we are going to end things out by talking about basically competition rules in the state of California. So you may know that California has some of the strictest laws that protect competition and worker mobility. So these are non-competes. Usually non-competes are not allowed. anti-rating clauses. So if you leave my employment, you are not allowed to hire my employees for the next year or 2 years, things along those lines. That's a backdoor non-compete. Those are not allowed as well. This is building on top of that. So this is talking about training, repayment agreement provisions, or stay or play provisions. So these are contracts or agreements that says an employee is going to pay for training programs if the worker leaves their job within a certain amount of time. Now, if you have questions about relocation bonuses or retention, we'll talk about that in a second. But let me just present this because there's a big exception, and that's really why I'm presenting this this law here. But anyways, let's just start with the base. We're talking about training programs here. So basically, it says that you cannot require an employee to repay if they leave within whatever amount of time it is that you designated their training costs. So specifically, AB 692 says these contract provisions are illegal with employees, requiring the worker to pay an employer, training provider, or a debt collector for a debt if the worker's employment ends. 2, authorizes the employer or training provider or a debt collector to resume or initiate collection of a debt if the worker's employment ends. Or it imposes any sort of penalty, fee, or cost on a worker if the worker employment ends. Right? So somewhat broad, but what from the legislators' perspective was that employers were using these types of agreements to keep employees at work for a certain amount of time. So they were economically constraining them from going on to another opportunity, so limiting worker mobility. And keep in mind, California is very conscious and very protective of worker mobility. So that's what the overall point of this law was to prevent that scenario. Now, like I said, there are some important carve-outs, and one of them I think will be applicable to several employers. So some of them much more broad. So we have exceptions here: contract entered for a loan repayment assistance program or loan forgiveness provided by the government. That doesn't apply. Contract related to tuition repayment for transferable credit, provided that certain contractual provisions are included. Also, we have an exception for apprenticeship programs, and then a contract related to the lease, financing, or purchase of residential property. Those are exceptions as well. But I wanted to focus on the fourth bullet point because, at least in my experience, when I interact with employers, and a lot of you folks in the construction industry, you provide sign-on or relocation bonuses. So there's an exception for that as well. But we have very specific requirements, and it's very important that you follow all of them. So it says that a contract for the receipt of a discretionary or unearned monetary payment at the outset of employment, so at the beginning of employment, not tied to specific performance, is accepted. But here are the requirements. 1, the repayment terms are separate from the employment contract. So maybe you do an employment contract, maybe you don't. But if you do an employment contract, usually, I mean, that could be, you're only being let go because of for cause, or some of it, sometimes it's just, a 1 or 2 page letter that says, okay, well, here's what you're going to get in pay, and here's what your benefits are, and stuff like that. If you do something like that, these repayment terms, if you're going to do a sign-on or relocation bonus, needs to be a separate document, so it's standalone. That's the first thing. 2, the employee is notified about their right to consult with an attorney about the agreement and is provided no less than 5 days to do so. So what is the best way to prove that you provided that notice? The best way to do that is to actually have it in the separate agreement that you are giving to the employee. So it would say you have the right to consult with an attorney, and you have 5 business days from being presented with this agreement to do so. That's 2. 3, the repayment is prorated based on the remaining time of any retention period, which must not be more than 2 years without interest accruing. Number 4 is that the worker may defer receipt of the payment to the end of the retention period without repayment obligations. So say you have an agreement in place where it says, you got this sign-on bonus or relocation bonus, and you got some language about 1 year. Like that's the magic number, right? They need to be there for at least a year, or you need to repay back some of that. The employee could say, okay, well, that's great, but how about you just give me the money? Don't give me the money now. Give me the money at the end of 1 year. So I guess it depends on the employee's economic situation, whether or not they do that or not, but they have the or they have the right to say, to have that option at least if they want to. And then the final thing is that the separation is either at the employee's sole discretion or due to employee's misconduct. So this is a really big thing here, right? So now you might have an at-will employee, and say you have a sign-on bonus and you have this agreement, but they're going to sue you when they're let go and said, hey, that agreement and that repayment obligation isn't lawful because it wasn't my choice to leave you and I didn't do any misconduct to justify it. That is a carve out of the at-will general rule that we have in California. So effectively, even though you might have an at-will employee, you might have to be litigating as if they weren't at will and show that there was some sort of misconduct, right? Essentially that there was cause for letting them go. So my overall point with this slide here is that this is a big deal, but there are some carve outs. But for the carve out that I think is going to be the most applicable to most employers, there's some very specific obligations that are in place. So you need to be mindful if you're going to do one of these things. With that being said, oh, I did have one more. Okay, let's talk about personnel records. So there are, in my opinion, two firms in California that have the same MO. They will send a letter to employers and say, hey, we represent this employer for potential claims against you. And we want that person's personnel records and time records. Sometimes it's a little bit more expansive than that. It might say that, oh, we want records of any instrument that an employee signed that relates to their employment. That's another obligation, but basically that's probably something that's going to be in the personnel file. So some employers take the view of, I'm not just going to respond to these things. Well, legally, that's not right. An employee has the right to ask for their personnel file. They have the right to ask for their pay records and their time records. For the personnel file, an employer has an obligation to provide it within 30 days of the request. For the time and pay stubs, effectively, an employer has to provide it within 21 days of the request. So I get a lot of these. I think actively right now I have about 6 of them going on. So usually I'll get one of these every 2 weeks or 3 weeks, something along these lines. I deal with this a lot, right? So usually what I do is that I'll get these letters and I'll tell my employer, okay, get me a personnel file, and give me their wage or give me their pay stubs, and give me their time records, give it to me, I'll sort it through, I'll redact things that don't need to be there, and then I'll give it off to the plaintiff's attorney or the potential plaintiff's attorney. And I always do that within 21 days. So I always use 21-day deadline. If you don't do this, there is a penalty. Now it's nominal. It's like $750, but it's automatic liability and there's attorney's fees there. So if you're going to get in trouble in a lawsuit, I would rather you get in trouble over something that's defensible. This is one of those things that it's late, it's just late, right? Like there's not many defenses that apply here. So that's just my overview of what we have with what your obligations are if you get one of those letters. Usually, by the way, the postscript is I send those documents off. Usually I get some sort of demand letter saying that the employer did everything wrong in the world against this employee. And then I'll get usually like some sort of settlement offer that's actually relatively low. And then it's usually 20 to 30 moves I have to do before I get a settlement in place. And usually the moves are like $200 or something like that. So it's mind numbing and it's really bothersome, but this part of it at least is required. So don't ignore those letters if you get them. But this law expands on what a personnel record is. So there is no definition of what a personnel file is in the labor code. The labor commissioner does have on their website some guidance as to what is in a personnel file. But at the end of the day, we just don't have a law that specifically says a personnel file is X, Y, and Z. But regardless, for this, it does tell us that something that does need to be retained and provided. So employees have inspection rights now are training records. So training records would include the employee's name, the trainer's provider's name, the duration and date of the training, what the training was about, and if there was a resulting certificate or qualification, what is that? So training could be for you folks, safety training. So you already have an obligation, an OSHA obligation to keep those records, but this is all the more reason to have sign-in sheets or some sort of certificate or some sort of proof that that training actually happened. So of course that would pertain to sexual harassment training. Remember workplace violence prevention plans from a couple of years ago? That's training you have to do too, right? Is that in there? And And then of course, your bias mitigation training if you're going to do that. But as most of you know, there's a lot of training that has to happen in California. And now the employee has the right to inspect records that relate to that topic. Okay, I think that this is, am I right? I am right. So I always do the plug for the podcast, which I think is going into its 11th year. So it's 5 minutes or so a month where I talk about something in employment law. Maybe it's new laws. I always do that November and December. So for those of you that were really excited about today, I assume that you went out last night, maybe with your spouse or significant other, and listened to the podcast from November and December and was, getting ready for what I was going to present today. But that's monthly. And it's usually, new case comes out, new set of regulations, something along those lines. And then occasionally we'll still do client alerts. It's not like during COVID days when we do a client alert every single day when everything was changing, but we'll occasionally do them if there's something out there. I will tell you one big thing that I have my eye on for the next year is whether or not rounding policies are allowed. That case is in front of the Supreme Court. Years and years ago, we had a case that said it was allowed. And then a couple of years ago, we had a case that said if you have the ability to actually track employees' time to the minute or be more precise with your time tracking, that rounding wasn't allowed. So that's for me, one of the bigger cases that is out there. And I'm sure I'll do a podcast on that. Maybe I even do a client alert. So you folks have our contact information. If you want to reach out with me and give me your contact information, we'll put you on the list for that. With that being said, I don't know if we have one more slide. We do. With that being said, that is the presentation. So if anyone has any questions, whether it's employment law related or construction law related, this is the time to share them. Otherwise, we will be saying goodbye until next year, potentially. So
Perfect.
Any questions out there?
Thank you, Aaron. Yes, we do have one that did come in. Can you send, and this is regarding SB 294, can you send Workplace Know Your Rights Part 1 in a group email?
Yeah, absolutely. You just need to have a record and retain it for 3 years that you sent that, right? So you're probably a group email, and I think actually that's how we did it here as well, right? But as long as you have a record that it went to specific people, that's absolutely fine.
Perfect. And another question related to that. If we have multiple work sites, does compliance happen company-wide or site by site?
Depends on what sort of compliance, but if we're talking about the Know Your Rights, it's going to be company-wide.
Yes, it was regarding SB 294. Perfect. And for those that are raising your hands, please go ahead and type your questions into the Q&A section so we can go ahead and answer any questions you might have. So far, that seems to be all of our questions so far. And I will give them a couple more seconds to possibly type that in. But if you wouldn't mind, Aaron, clicking to the next slide in the meantime.
Yes. Well, you want to see the disclaimer? Okay. There you go.
I mean, that's so entertaining.
There's another Q&A.
The next one.
Once again, if you have questions, here's your second reminder. I think it's this one, right?
Yes. So we are proud to offer our Bender U classes on a regular basis, on a monthly basis. So if you scan this QR code, it will take you to our full list of classes. And you can go ahead and register yourself. And of course, in that time, we did have a couple more questions pop in. For Know Your Rights, can we provide a paper copy in the employee's paycheck stub?
Yeah, absolutely. So the law says that you are allowed to distribute it in the customary way that you would otherwise distribute notices and things along those lines. So yeah, but again, the important thing on your end is that you're going to want to make sure that you keep that proof that you provided that distribution for 3 years. And remember, that's an annual obligation, so it's going to be rolling. So there's always going to be something about know your rights, presumably, in your employee's personnel file. But yes, you can.
Perfect. And the remaining comment that came in is just a big thank you for sharing this valuable information, which dovetails really nicely into just my little wrap up here. But friends, if you do have questions that pop up afterwards, that does tend to happen. please reach out and we will gladly connect with you individually. But just a huge thank you again to the amazing team at Murphy Austin for sharing with us today. We appreciate you all taking time out of your busy schedules to join us for today's Vendor U. And as a reminder, this session has been recorded, and both the recording link and a copy of today's slide deck will be emailed to you following the webinar. But thank you again. We hope you all have a wonderful day and a safe 2026. And thank you again to Murphy Austin team. You guys are wonderful.
Thank you.
Yeah.
Vendor.
Thank you.
Have a great day.